Just 2 minutes before I left, item 48, Union of India was a big party. Perhaps notices have been issued. Are those?
क्या होगा कुछ
क्या करना होगा?
नोटिस जाएगा आप एपियर हो जाइएगा कुछ एडवर्स
दो
ऑर्डर
मिनट पहले बस 24 मतलब 1:28 हो रहा था, हमको लगा नहीं होगा.
कोई ऐसा एडवर्स ऑर्डर हम नहीं करते अपीयरेंस नहीं रिकॉर्ड करते
नहीं अपीयरेंस जब हम नोटिस देंगे अब
जाएगा स्पीड पोस्ट से जाएगा अगला डेट में आप अपीयर हो जाएंगे ऐसा एडवर्स ऑर्डर हम नहीं करते बिकॉज आई एम कॉन्शियस कि लोगों का बहुत स्टेक्स होता है
1:28 में हम लोग को लगा कि
आज थोड़ा सा हम लोग की तरफ से भी गलती हुई है डिस्प्ले बोर्ड में कुछ एरर भी
हमको लगा कि नहीं मतलब 4-5 केस से नहीं होगा 2 मिनट है.
नो एडवर्स ऑर्डर हैज बीन there is yes when will you credit the amount
Should I have taken
it is irrespective of
yes I accept. I have spoken to him. He is willing to do it within a week by 12th. His only stand is he was never given the bank account details. They should give the name, the bank account and the IFSC code in the communication.
order में लिखा हुआ ना
Order में नहीं लिखा हुआ.
But we had also transmitted the amount minutes by way of.
No, but that recipient detail में नहीं
नहीं हो
आता
सकता
है.
ना।
IFSC नहीं
We
आता.
provide the bank account.
अभी
Right now.
लेके आइए ठीक है इसका
By
क्या
12th he will return refund.
अभी लेके आइए
After Chhath Puja he will.
counsel for the parties are present
Item 37.
yes serial number 7
37.
serial number 37 contempt civil 796 of 2024 counsel for the parties are present the learned counsel for the opposite party number 2
Number 2, opposite party.
has submitted on instruction that the amount will be remitted to the bank account of the petitioner if necessary details are provided. He submits that the needful will be done by 12th of November. The counsel for the petitioner has furnished the bank account details where the amount is to be remitted. Same account होना चाहिए.
Lordship, funds.
Otherwise आपको इनकम टैक्स में डिफिकल्टी हो जाएगा ठीक है
Give the account details.
Pose this case on 19th of November in the supplementary cause list. The supplementary the show cause be filed annexing therewith the proof of such deposit.
From supplementary list, fixed case item 1 WPL 1798 of 2009.
This was heard yesterday. Just I shall summarize what I had advanced on the last occasion. अवार्ड का पैरा 15 एक बार पढ़ दें थोड़ा सा गड़बड़ी है.
But
13 से पढ़ लेते हैं. 13 का जो
no, we have read it.
Yes.
There is no problem
It
about
was,
it.
it just I shall summarize that in para number 14 it has been held that inquiry has been declared to be fair and proper because there was no procedural latches in the inquiry, principles of natural justice has been followed and the dismissal order has been passed after obtaining approval from the general manager.
There is no problem on
There
that.
is no problem on that. Now, there are certain things I had also searched in the file, the supplementary affidavit, though it's in my file, it has not been filed. The basic purpose of filing this supplementary affidavit was to bring on record a subsequent development, which was the acquittal order by the court of the judicial magistrate first class at Hiba. There are certain permissivities in the order because it's the law is certain that if I am able to show any permissivity, then only I will succeed. Else, there is no scope for reappreciation of evidence in 227. Things would be clear if your leadership had a reading to the internal page 6, that is the page number 37 of the award.
fifth line from the bottom.
Page number 7,
Page number 6, internal page 6 of the award.
page 36. Internal page 6 is 37.
Yes, yes, 37.
5 के बाद मेरे पास 7 और 6 इधर.
Fifth,
Page
parallel-
37 of the award.
जी, bottom say, fifth line from the bottom. Regarding his absence on the date of incident such and such, an FIR has been lodged by the management against the concerned workman and also against the certain workers. It shows that the incident has taken place and FIR number such and such has been lodged. In this respect, the concerned workman stated that he has been acquitted in the above case. In this respect, the learned lawyer for the management has argued that the concerned workman has been acquitted on ground of the hostility of the witnesses. It shows that the concerned workman is more powerful to get the witnesses hostile, hostile to his witnesses stated in the FIR as per the civil suit number such and such, titled such and such, in which case compensation and damages has been demanded by the management against the workman amounting to Rs 9 lakhs and odd, resulting in the loss caused to the company due to the act of the workman on 29/12/1998. Now you realize it. How is this perverse? I shall just explain it. This award was passed on 22nd of July 2008. I've also mentioned the dates in my list of dates which have
Yes.
been handed last year. And this acquittal order has been passed on 13th November 2009. So a question can be posed to me that if it was passed in 2009, how my counsel submitted that I have been acquitted? My counsel had submitted that the deposition, which was exhibit W1 to W4, the deposition, certified copy of the depositions were marked by us as exhibit, saying that the witnesses have got hostile. But inadvertently, the sentence of this award says that I have been acquitted. But that is not possible because this is an error of record. Because the order was passed on,
From where do you say this?
because this runs contrary. हम judgment
आप अपने हाथ में रखे
नहीं,
नहीं इसका हम कर ही क्या
वो
सकते
supplementary affidavit
I
फाइल
do
नहीं हो
not-
पाया
it is
था,
not possible.
इसलिए हम ये चीज बता रहे हैं कि
So
कोई चीज-
therefore, on the day when this order was passed, there was no order of acquittal.
there was no order of acquittal.
So
Only
therefore, how
the
does it
witness.
help you?
So only the witnesses had got hostile on that day. This is my submission.
That's
I'm only submitting. Thereafter, I had submitted yesterday that the civil suit which was filed against me for stating that due to my misconduct, there was a loss of production. Though I don't have the certified copy of the order passed of the dismissal of the civil suit, that has not been marked before the court below. But that has not been disputed by the management that I am making a false statement in my read. Because the specific statement has been made
See,
in my
these
read
things we
that
cannot appreciate. We will only see the inquiry report, the findings in the inquiry report and publicity. And so far as this acquittal is concerned, it is this consideration is perverse and therefore that does not make a sense at all.
Your
According
Lordship-
to you, there was no order of acquittal.
Yes, there was no order of acquittal, but Your Lordship,
So therefore, what remains? What remains is
proportionality of punishment.
yes,
It has to be seen whether my misconduct I should have been saddled with a dismissal order, or there ought to have been any other punishment save and except dismissal. The operative portion is just in one paragraph. The presiding officer has discussed about inquiry report, the contents, each and everything has been discussed, my past misconduct. But in para number 17, he has just written in one line, I had submitted yesterday. I have gone through the entire paper submitted, issued charge sheet dated by which the concerned workman has submitted his reply, which is exhibit 2 for dropping the charge sheet. The inquiry report shows that the concerned workman was present in the proceeding and he has fully participated in the inquiry. After concluding the inquiry, a letter was issued to field management along with the inquiry report as received by him after he made a representation dated management. After considering his representation and after giving the copy of the inquiry report, passed an order of dismissal. This shows that the concerned workman is indisciplined. this is the first apparition upon me. Such person should not be made in service of management. If a person like him is allowed to remain in service, it will create an atmosphere of indiscipline and the industry resulting in loss of production and unrest in the industry. I read the following about. In just one line, in one paragraph, he has mentioned that I am an indisciplined
The
person.
court has made it clear that you are not fit for being taken back in service.
Yes, it says
Your
that.
conduct is such that it may cause loss and industrial unrest. Sufficient.
Your Ladyship, in my respectful submission, since the domestic inquiry, the departmental proceedings and a criminal case was lodged on similar set of charges, so my humble submission is
No, the
that
point is that you
Let-
say that in the criminal case you were not yet convicted.
Your
So
Ladyship,
what remains?
Your Ladyship, that is an error of record because
That is
I
an
am
error
sub-
of record. So you have been subsequently acquitted.
acquitted.
So you
In
want
the
your
end,
order of acquittal to be taken into
consider,
consideration
I am only
by
praying
this
that-
court for the first time. It's not that we may consider it, right? But the point is that so that will not fall on the perversity in the sense that the court has not considered your order of acquittal.
Your Lordship, I was humbly praying that let this matter be remanded
No,
back.
no,
The
no.
court below should take into consideration for
not-
similar set of charges I have been acquitted.
You
And
see-
then fresh, after hearing the parties a fresh order be
We do
passed. I
not-
am just praying that. And in support of these submissions, yesterday I had relied upon certain decisions
Yes,
of
we
the
did.
Honorable Supreme Court of my written notes of argument, the internal page 6 on the proportionality of punishment. I may be permitted to place those certain paragraphs. 5 judgments I am relying upon. Books are here.
Yes, the principle is very clear. We don't have any doubt on those principles. All the principles, whatever you have cited, we fully agree. But the point is whether those principles will come to your rescue. That is the whole point. The principle of law laid down by the Honorable Supreme Court, there is no scope for me to dispute
Yes.
that.
Acquittal orders also says that आपको दोषमुक्त किया जाता है on the ground that
Acquittal
all
order, you see, so far as the award is concerned, at that point of time, the order of acquittal was not there according to your submission,
Yes, yes.
right?
Because that can't
So
be
therefore,
because it
that
has been
can't
passed
be.
in 2009.
Therefore, the acquittal order was not subject matter of consideration.
Yes, but the deposition of the witnesses
That
W1 to
cannot be taken into consideration. How can that be taken into consideration?
Your Lordship,
Deposition and you see why am I not inclined to remand this matter? Because the set of witnesses are totally different. And that you have seen Ramlal's judgment.
रामलाल पास का सजा।
देख लिया ना उसमें है सेम विटनेसेस सेम सेट ऑफ एविडेंसेस होना चाहिए सेम चार्ज होना चाहिए यू सी अराइजिंग आउट ऑफ वन इंसिडेंट
चार्ज तो यहाँ भी सेम
We
है
do
लेकिन
not know-
गवाह अलग अलग है
अरे
क्रिमिनल केस
तो
के
गवाह अलग अलग होने से बहुत फर्क है ना बहुत फर्क है इट्स जस्ट नॉट वन एंड द सेम इफ द विटनेसेस आर डिफरेंट
इसमें मेरा हम्बल सबमिशन
आपका हम्बल सबमिशन हम नोट कर
ये
अब बताइए क्या
proportionality of punishment पर कि जो भी एलिगेशन मेरे ऊपर था कि had excited the workers to climb top of the headgear in the और क्या कहते हैं CI सब
You see,
जमाना
in your inquiry report, right? In your reply also, I have seen, you have not denied the incident.
Yes, sir.
You took a plea of alibi. You were not there, right? But the manner in which this incident had taken place, you had virtually choked them inside the mind.
It has
Inside the
नहीं, वो
mind.
मशीन बंद होने के
एक मिनट के लिए भी
एयर
एक मिनट के लिए भी अगर आप दूसरे इंक्वायरी को चोक कर देते हैं इट्स वेरी सीरियस यू कांट डू दिस एंड एवरीथिंग हैपेंड बिकॉज ऑफ ऑर्डर्स ऑफ ट्रांसफर
उन लोगों का ट्रांसफर
किसी का भी ट्रांसफर
5 लोग के थे मेरा सबमिशन
वो ठीक ही लिखे हैं दैट यू आर अ थ्रेट
प्रोपोर्शनलिटी ऑफ पनिशमेंट पर मेरा है कि ये जो चार्ज मेरे ऊपर लगाए
डील करेंगे ना आप चिंता मत करिए आपके सारे सबमिशंस
डिसमिसल छोड़ के एनी अदर पनिशमेंट किया जाए और ये जो 5 केस लॉस व्हिच आई हैड रिलाइड यस्टरडे दोस केस लॉस में भी
ठीक है पहले आपका सबमिशन लिखाते हैं फिर इनका सबमिशन Heard the learned counsel for the petitioner. The learned counsel for the petitioner submits that the petitioner was dismissed from service after conducting conducting domestic inquiry. The domestic inquiry was held to be fair and proper, and the petitioner has no grievance so far as the domestic inquiry is concerned. He has submitted that the learned tribunal or court,
This is travel.
the learned tribunal has recorded that the petitioner that a plea was raised, that the petitioner has been acquitted from the in the criminal case, and the witnesses, on the ground that the witnesses had turned hostile, the learned counsel submits that the order of acquittal was passed only on 30/11/2009, and the award is dated 22/7/2008. The learned counsel submits that the case of the petitioner before the learned tribunal was that the witnesses who had deposed in the criminal case had turned hostile. It was never the case of the petitioner that the petitioner was acquitted at that point of time. However, the petitioner has been acquitted later on 13/11/2009. He has referred to the discussion made by the learned tribunal in this regard in para number,
Starts from
in para 15
to 17.
15 to 17 of the impugned award. The learned counsel has further submitted that a civil suit was also filed by the respondent, being suit number 2 of 1999, in which a compensation and damages was to be determined, which was to be payable by the petitioner, amounting to rupees 9,12,000, relating to the loss caused to the respondent due to the act of the workman on act of the petitioner on 29/12/1998. The learned counsel submits that though the final judgment in civil suit number 2 of 99 is not in his possession, nor the same has been brought on record, but to the best of his information, the civil suit has already been dismissed. He also does not have the date of dismissal of the suit. The learned counsel submits that once the civil suit has been dismissed, it goes to show that management did not suffer any monetary loss. While in furtherance to the argument, the learned counsel has submitted that once the disciplinary proceeding is held to be fair and proper, it was incumbent upon the learned tribunal to consider the proportionality of the punishment. He submits that this aspect of the matter has not been considered by the learned tribunal. His submission is that the aforesaid aspects of the matter have serious bearing, and therefore the matter be remitted back to the concerned court to take into, so that the acquittal of the petitioner, the dismissal of the suit, and the quantum of punishment be taken into consideration. The learned counsel has relied upon the following judgments. It will be C.
It will be A. Was A.
Firestone.
नहीं Firestone और उसके बाद में कोई
A and B तो Firestone है.
हाँ A and B
A and B वो हो गया. इसके बाद
C D E F G
C D E F सबका पैरा नंबर 2 है, ठीक है. एंड एक और जजमेंट है.
G
ब्रैकेट 2010 ब्रैकेट क्लोज 9 SCC 497 पैरा 47. That's all. और कुछ बोलना है? आपको क्या बोलना है? स्टेट रेस्पोंडेंट.
प्रोपोर्शनैलिटी में एक छोटा सा जजमेंट खाली दे रहा हूँ 2000 judges 2005 3 SCC 134
3 SCC 134
134
पैरा
yes paragraph 20
पैरा 20.
yes. Here charge was of abusing only and the Supreme Court held that that is even sufficient for dismissal.
This is on proportionality.
Sorry,
This is on proportionality.
proportionality, the head note also is there.
That's
It is
it.
only on the point of proportionality.
What about other points?
Other points, so far as acquittal in a criminal case, although it was not there before the tribunal, we have judgments. If your lordship allows me to cite, and otherwise that
Cite
is not a relevant
one best.
consideration.
One best.
Yes, one best. That would be 2022. Liji. 6 SCC 563.
Ramlal.
This is State of Karnataka versus Umesh.
पैरा
Para 16 minute. The last line of that para 16, the acquittal of the accused in a criminal case does not debar the employer from proceeding in exercise of disciplinary jurisdiction. Here, disciplinary action had already concluded much before the criminal case ended in acquittal. 1999 is the dismissal. 15/9/99 is dismissal. Then criminal case award was passed on 22/7/2008 and acquittal is 30/11/2009. So disciplinary action had already taken place in 99, 10 years before this acquittal in criminal case supposedly. So my submission is disciplinary action is under test. They did not raise any objection with regards to the fairness and propriety.
That's
So what is to be considered is whether the punishment is proportionate or not. That is can be borne out from the provision of section 11A itself. That is what is to be considered, and that has been given consideration. There are serious charges against him. I need not repeat. Inciting others, riotous behavior, then closing down a portion of the mind, causing danger to life of others, then abuse, then causing loss to the company. So these are the charges. So taking into consideration everything, that paragraph notes everything that I have considered this, and finally this is the holds that it is sufficient. This is all.
set of witnesses are also different.
They are different. So that judgment, if your lordship wants.
The judgment of acquittal can we have a look?
Yes, your lordship may.
Because they are not filed it by way of.
highlighted like they are.
Sorry,
I'll also give another judgment.
you have highlighted. कोई बात. This is judgment of acquittal.
Yes.
No. The learned counsel appearing on behalf of the respondent while opposing the prayer has submitted that so far as the point of proportionality is concerned, he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2022 bracket close 6 SCC 563 para 16, and he has submitted that the acquittal of the petitioner in criminal case does not the acquittal of an employee in the criminal case does not debar the employer from proceeding in the exercise of disciplinary jurisdiction. He has also submitted that in the judgment, in the aforesaid judgment, the allegation was only of abuse, and in spite of such allegation, the order of dismissal was sustained. He has further submitted that the order of dismissal in the present case was passed in the disciplinary proceeding on 15/9/1999. The award was passed on 22/7/2008, and the judgment of acquittal was passed on in the criminal case was passed on 13/11/2009, meaning thereby that on the date of his order of dismissal in the disciplinary inquiry and also on the date of the passing of the award, the petitioner was not acquitted in the criminal case. He has further submitted that once the disciplinary inquiry was held to be fair and proper, the scope is very limited. Only the proportionality of punishment, primarily the proportionality of punishment, was to be taken into consideration. The allegation against the petitioner are very serious in the sense that the petitioner had taken the unit of the respondent
At ransom.
at ransom.
He had incited other workmen.
He had incited other workmen and put the life of a few in jeopardy
Yes.
and had caused damages to the establishment of the respondent.
197 persons were trapped.
197 persons were trapped in the colliery.
Yes.
In the colliery.
In the
That
mine,
should be
inside
correct.
mine.
Inside the mine, though for a short period. The learned counsel has also submitted that even the set of witnesses in the criminal case
And the domestic.
and the domestic inquiry were totally different. रामलाल वाला जजमेंट आपने देखे हैं?
And
रामलाल वाला जजमेंट में दिया हुआ है सिमिलर सेट ऑफ विटनेस भी होना चाहिए.
हाँ, एक और जजमेंट हम लेके आए थे.
Anyways, that should be something.
पांडियन रोडवेज आपने देखा होगा.
हम उतना हमको याद
याद है, खोज
नहीं.
और-
कल हम खोज के निकाले थे वो रामलाल
I
वाला
can give
जजमेंट.
that Pandian roadways case.
ये तो सीधा कल बोल दिया कि मेरे अगेंस्ट पे है तो हम साइड नहीं करेंगे. Right? Yes.
अगेंस्ट में तो नहीं साइड करेंगे,
That's
तो
right.
थोड़ी हारेंगे.
कोई बात नहीं. It's a part of your duty.
In response,
हाँ,
whatever
बताइए.
my senior friend has argued, in response, I shall say two things. Charges of abusing do not fall in the charge sheet. ये charge sheet जो हमको दिया गया उसमें कोई abuse का
Abuse
charge
नहीं है. अच्छा ठीक.
दूसरी चीज substantial loss जो प्रोडक्शन का जो कह रहे हैं, सिविल सूट डिसमिस हो गया, सिविल सूट इन्होंने फाइल किया था, इनको ओनस इन पर था कि सब्सटेंशियल सूट को अपना कंटेस्ट कराते,
ठीक है.
मेरे ऊपर डिग्रेड करा देते, सूट
सही.
हो जाता, सूट गॉट डिसमिस्ड और इन्होंने कोई अब उस डिसमिसल ऑर्डर के सूट को रिस्टोर कराने का भी
अभी
कोई
तो ना तो
नहीं
सूट
किया.
का डिसमिसल ऑर्डर का पता है, द डिसमिसल का डेट का पता है.
सबमिशन हुआ जो अवार्ड में ये चीज आया है कि पैरा नंबर
डिसमिसल का बात कहाँ आया है?
सिविल सूट 2 ऑफ 1999 जो लिखा हुआ है कि बीसीसीएल वर्सेस सोमरू यादव एंड
पेंडिंग
नहीं, पेंडिंग नहीं है, केवल लिखा हुआ है कि सिविल सूट दाखिल किया गया.
पेंडिंग ही हुआ ना. ठीक है. In response, the counsel for the petitioner has submitted that there was no allegation of abuse against the petitioner, and so far as the substantial loss to the company is concerned, the civil suit seeking damages and loss has been dismissed, and therefore such arguments are not sustainable. Such arguments of the respondents are not sustainable. That's all. Arguments concluded. Post for judgment एक date देते हैं. Judgment का date. रामलाल वाला जजमेंट नहीं मिला?
मिल गया हमको. उसका मिला है. ये सुप्रीम कोर्ट रिपोर्ट्स का है. साइटेशन हम तुरंत हम लिख के दे देंगे.
देख देते हैं. The counsel for the respondent has also relied upon the judgment passed by the Honorable Supreme Court in the case of Ramlal.
वर्सेस स्टेट ऑफ राजस्थान.
Ramlal versus State of Rajasthan. Civil appeal का नंबर दे दीजिए.
हाँ, सिविल अपील नंबर 7935 of 2023.
7935 of
2023.
ये कल हम फॉरवर्ड किए थे उनको, आपको किए हैं, है ना? ये इनको भेज देंगे. That's all?
Yes.
For judgment on 10th of December. तो खा लेंगे आपसे 10 तारीख तक वेट नहीं करना
Survey case item 4, WPC 6823 of 2019.
Yes, what is it?
That is for the petitioner is neither
ये
a
एक तो
judgment letter or decree holder measure. But it is part of that. Title in this bill was filed against her.
you see if there is a certificate proceeding against you, there is a certificate proceeding
Yes,
against
I have challenged that matter on the ground that under section 9 I have challenged matter.
you. You have
On the
filed
ground
your objection under section 9.
Yeah, I have filed.
It has been rejected or pending?
It has
That
been
is my
rejected.
lord, I have my lord, I have
It is
to
pending
seek
or
instruction. I will
It has
file
been
something.
rejected, my lords. Annexure, my lords, may have annexure A of the contract, my lords. Page 23.
Therefore, I will file supplementary affidavit. I have no knowledge. This writ petition I had filed in the year 2019. And thereafter, what has been done there. So all these things I will brought into. I will
My
bring
lords,
to
he
my-
stood as a guarantor for the said truck and got the truck released from the police custody, my lords.
So that is a criminal case. It was.
My lords, he can file appeal against the rejection order.
Truck was released at the time of the surety. That is in the criminal case. So far this title, motorbike accident claim case is concerned. The petitioner is the Kishori, the owner of the truck is Kishori Devi, and her husband is named as Kishori Devi, wife of B.N. Tiwari, not the petitioner. Petitioner has no concern in any matter. Sometime
How much is the amount?
1,50,200.
But he is.
एक बात बताइए 1,50,000 200 250
200.
he stood as a surety in the release of the vehicle.
In the criminal
As
case.
a guarantor.
Guarantor थोड़ी होता है.
One surety, my lords.
Surety.
Surety का liability is joint and several. Under what provision of law? आप इसको समझिए. बताइए. Surety का liability will be joint and several. अब जो bail bond furnish होता है या surety, you have to find it out. It's very important to find it out. If a person is standing as surety, right? तो वो अपना उसका अमाउंट फिक्स होता है ना उसका लाइबिलिटी का. उतना ही बार उससे रियलाइज कर सकते हैं कि पूरा ट्रक का वैल्यू उनसे रियलाइज करना है. बताइए.
If the vehicle was not released by him, we would have auctioned the vehicle.
You see, if the vehicle was not released, you see, there is a vehicle. अब 10 लाख का ट्रक है, तो 10 लाख का तो सियोरिटी का 10 लाख का लाइबिलिटी हो जाएगा इनका. कितना हो जाएगा? जितना का बॉन्ड देंगे उतना का ही होगा. आई डू नॉट नो व्हाट इज द प्रोसीड्यूर. आप इसको समझिए. बेल बॉन्ड फर्निश होता है, भाग जाता है, तो क्या करें? उसको दूसरा आदमी को सूली पे चढ़ा देंगे. जो बॉन्ड देगा उसको चढ़ा देंगे सूली पर. उसको कन्विक्शन, उसका कन्विक्शन कर देंगे क्या? नहीं करेंगे ना. थोड़ा समझाइए हमको. ऐसा नहीं है. लेट अस अंडरस्टैंड. It's surety. I do not know. I just do not know. I have not examined it, but when I saw the brief, I just thought that it is a point which is required to be discussed. It is an admitted fact that he was not the owner of the vehicle. Admitted fact. It is also an admitted fact that he stood as a surety at the time of release of the vehicle. Now we have to see that what is his liability. His liability will be joint and several because it is not guaranteed. Surety is not guaranteed. यू एग्जामिन इट. आप भी कुछ बता नहीं रहे हैं, बताइए.
तो किसी का है मालूम दिस
अरे भाई थोड़ा लॉ बताइएगा ना, बताइए, हम आपका फेवर में डिसाइड कर देंगे. बताइए.
फेवर ऑफ द मालूम जॉइंट कैसे
देखिए ऐसे नहीं, आप प्रोविजन ऑफ लॉ दिखाइए, सियोरिटी कैसे होता है, हम लोग नहीं देखेंगे.
इस पॉइंट पर मालूम
हाँ, सियोरिटी जो आप दिए होंगे ना, जो सियोरिटी आप दिए होंगे ना, उसका कोई डॉक्यूमेंट होगा, उसमें जो कंडीशन होगा बस वही कंडीशन होगा, लेके आइए. किस केस में आप दिए?
क्रिमिनल केस में दिए थे ट्रक रिलीज के समय.
बताइए कौन सा केस नंबर?
उसका डिस्क्रिप्शन पूरा मेरे पास नहीं है.
केस, क्रिमिनल केस का नंबर नहीं है?
क्रिमिनल केस का हम पूरा नहीं किया. हम इसको फाइल कर सकते हैं, सप्लीमेंट्री करके फाइल करेंगे.
क्या सप्लीमेंट्री? क्रिमिनल केस का नंबर हम देखे हैं इसमें.
तो क्रिमिनल केस का तो नंबर है,
बट वही तो पूछ रहे हैं.
कतरास पीएस केस नंबर 409 ऑफ 2000 ऑफ 1992.
कतरास पीएस
केस
केस नंबर
नंबर 409
409
1992.
1992. इसका क्या हुआ? फाइनल ऑर्डर, कन्विक्शन हुआ, क्या हुआ?
इसका स्टेटस इसको फाइल कर देंगे, सप्लीमेंट्री करके फाइल कर सकते हैं.
आप समझ नहीं रहे. आप जाइएगा ना तो आपको डॉक्यूमेंट नहीं मिलेगा, रिकॉर्ड यहीं से मंगाएंगे, तो आ जाएगा यहाँ पर, देख लीजिएगा और समझ के समझिए.
तो क्लियर.
लेकिन थोड़ा सा अपना थोड़ा होमवर्क कर लीजिए, हम लोग को नहीं पता है सियोरिटी का क्या डॉक्यूमेंट होता है, क्या टर्म्स एंड कंडीशंस होता है, आप समझ गए? तो उनसे भी आप समझ लीजिए. ऐसे सियोरिटी को आप ऐसा, तो हमको तो नहीं लगता प्राइवेसी कर सकते हैं. आपको फाइनल, ठीक है. मिस्टर राजीव कुमार, आपको पता होगा, कुछ आइडिया है? मतलब हम लोग तो देखे नहीं है वो डॉक्यूमेंट.
श्योरिटी का लायबिलिटी को एक्सपेंसिव होता है, लेकिन क्रिमिनल केस में नहीं होता.
क्रिमिनल केस में नहीं, ठीक है. इसको हम
कॉन्ट्रैक्ट
लोग
लॉ में
हाँ.
if I become a surety of someone, somebody takes a loan that I become a surety, then I'll be also liable.
जॉइंट एंड सेटल,
वो expensive.
जॉइंट एंड सेटल,
वो expensive.
बट नॉट इन अ क्रिमिनल.
Not in.
समझ गए? देखिए आपको कितना बड़ा ज्ञान मिल गया. इसको जरा करिए, इसको डिसाइड करेंगे, ठीक है. देखिए WPC number 6823 of 2019. The learned counsel for the parties are present. Counsel for the petitioner submits that the petitioner stood as surety in the for the purposes of release of truck in the criminal case, which was arising out of Katras case number 409 of 1992. The learned counsel is not aware as to what happened in the criminal case, nor he has the case number.
क्रिमिनल केस का तो नंबर लिखा था.
क्रिमिनल केस का तो सिर्फ पीएस केस नंबर है ना, ट्रायल नंबर तो नहीं है ना आपके पास.
जीआर नंबर तो था.
The liability in the present case against the owner of the vehicle was fixed at rupees 1,15,200, and the proceeding has been initiated against the petitioner for realization of the entire amount with interest.
With interest.
With interest. The learned counsel for the petitioner seeks adjournment to prepare himself in this case.
नहीं, लेकिन लॉर्डशिप वहाँ पर उनको ऑर्डर हुआ है देने को. ट्रक ऑनर इनका नाम नहीं आया, सिर्फ प्रोसीडिंग नहीं.
कोई बात नहीं, देखते हैं, ठीक है. ऐसे डिसमिस करना होता है ना, अभी आपको डिसमिस कर देते हैं कि आप एपेलेट अथॉरिटी के पास चले जाइए, उसके बाद वहाँ 40% डिपॉजिट करके लड़ते रहते हैं. कब आप हमको बता सकेंगे?
इसको बताएंगे आफ्टर वेकेशन. उस टाइम में दिया
पोस्ट ऑन 12th of November. हाँ, सप्लीमेंट्री कॉज लिस्ट. You also examine it.
नीचे नहीं क्या सप्लीमेंट्री फाइल करना पड़ेगा.
केस नंबर दे देंगे तो हम लोग मंगा लेंगे.
12 नंबर को
केस नंबर बता देंगे, उसी से मंगा लेंगे. खाली केस नंबर.
केस नंबर से ले सकता हूँ.
आप खोज लीजिए पीएस केस नंबर से, जीआर केस नंबर से. केस नंबर बताइएगा, हम लोग रिकॉर्ड मंगाएंगे, ठीक है. और इसका भी रिकॉर्ड मंगाएंगे, इसका भी रिकॉर्ड मंगाएंगे. सर्टिफिकेट के पहले जो ऑर्डर हुआ, ठीक है, 12 तारीख को रखने सप्लीमेंट्री प्रोसेस.
Item 5 WPL 579091 of 2023.
Yesterday, your lordships have passed an order that there is a provision of appeal. The provision of appeal will come into force only if the learned court of the commissioner has any territorial jurisdiction, meaning thereby that if the cause of action arises within the territorial jurisdiction of the learned court, then only your lordship he can either hear the matter or pass an order. And if without having any jurisdiction,
कल का ऑर्डर कहाँ है? Just a moment. सुबह तो हम पढ़े रहे थे. आई नहीं तो नहीं. Yes, please. आपके पास होगा ना? ठीक है, कोई बात नहीं, रखिए. हाँ, yes, yes. So there is no territorial jurisdiction of the learning commission according to.
because your lordship, the cause of action arose at Bangalore.
The accident had taken place at Bangalore.
And none of the, even a part of the cause of action, your lordship, arises within the territorial jurisdiction of the state of Jharkhand. And as such, your lordship, he did not have any authority. And in spite of that, he has passed an order. Secondly, your lordship, that there was no notice ever served upon the present petitioner. And as such, it is a clear violation of the principles of natural justice. In view of the fact, your lordship, until and unless the notice is validly served or the petitioner has any inkling about any case being filed as against him, your lordship, this order is liable to be set aside by this honorable court.
The order reveals that the notice was served, but you did not answer.
Your lordship will please.
It is wrongly recorded. Could
Yes, yes, we have stated in our application. It was never served.
Where was the FIR filed?
Yalanka police station. And your lordship, the learned commissioner, he has given a judgment or an order, your lordship, of at least 10 pages.
You just come to page number 78. This is Yalanka, PS case number 161 of 2019. Isn't it?
In the district of Bangalore.
For the purpose, this is employees' compensation.
Employees' compensation.
But for the purposes of Motor Vehicles Act, the case can be filed anywhere, isn't it?
No, your lordship, the cause of action has
to be within the
territory of that court.
We'll issue notice.
Notices have already been issued, your lordship.
Sir.
Please, yes, and we got it published also in the newspaper, and they are not appearing. We have filed an affidavit. Please just have a look to the last two orders. In spite of that, they are not appearing.
On 24/10/20, there is an office note that the supplementary affidavit regarding substituted service has not been filed. और यहाँ पे लगा हुआ.
Now thereafter, your lordship may please just have a look to the order wherein it is stated that we will get it published in the newspaper. And that has also been done. In 2 newspapers, Your Lordship, we have got it published. And to that effect, we have also filed an IAE.
In which newspaper have you got it published?
Yes, we have stated.
And कहाँ का वो है edition?
Bokaro.
इसका कोई एग्जीक्यूशन चल रहा है? कोई एग्जीक्यूशन इसका चल रहा है?
That will go on. We are not very much.
नहीं, a person cannot pursue the execution case and not appear in this court simultaneously. इसीलिए पूछ रहे हैं.
No, Your Lordship, the matter has to be decided whether he had any authority.
No,
or
it will be decided. It will be decided. The point is that in spite of notice, he is not appearing. I'm saying something in your favor.
No, I am just
If a
saying.
person is not appearing in spite of notice and pursuing his execution, then we will stay the execution proceedings and get him served through the executing court.
That I'm very much obliged to you.
My lord,
You are for whom?
I am insurance company, my lord.
Okay.
Section 21 may be look into. There is a specific provision for the territorial jurisdiction.
Section 21.
21.
We decide to करना होगा ना.
Yes, my lord. I am not there.
No, first,
Only I am assisting the
Venue
court.
of proceeding and transfer.
Transfer, yes. Where any matter under this act is to be done by or before a commissioner, the same shall subject to the provisions of this act and to any rules made hereunder be done by or before the commissioner for the area in which A. the accident took place which resulted in the injury, or B. the employee, or in case of his death, the dependent claiming the compensation ordinarily resided.
So under B it has been.
B. My lord, in this matter, I have judgment in support of my lord.
Let us.
And this is the Supreme Court judgment, my lord.
तो लगता है हम डिसाइड किए हैं केस में. याद नहीं है.
One judgment is, as the maintainability of the writ petition, I have got the copy of that judgment. That in case of natural justice, the appeals should be filed.
No, it will be natural justice के बारे में बात नहीं करेंगे. पहले jurisdiction वाला बात करिए.
Yes,
Natural
yes.
justice का बात नहीं करेंगे. What do you have to say to this judgment, Mr.
Your Lordship, please judge. Very, very beautiful judgment of the Honorable Supreme Court.
On this particular subject?
Yes. This is a judgment which is to be considered as a landmark, Your Lordship. Please just directly come to.
This is interpreting section 21.
Section, yes, Your Lordship. Only whether alternative remedy.
No, this is not an alternative remedy. You see, you have 2 points. One is territorial jurisdiction,
Territorial use, yes.
and other is or this natural justice or alternative
Yes,
remedy,
yes.
right? So first, let us see, because he has given a judgment directly on this point, and he has referred to section 21. Therefore, you satisfy.
No, firstly, he says that appeal should lie.
No. You see, when it comes to jurisdiction, we can decide a writ petition. But he has referred to section 21B
Yes.
of the Act, which says that in case of death, wherever the legal heirs are residing, they can file a case over it.
They can file a case there, and then we can come here before this honorable court against that order.
Certainly.
And
Certainly.
we have filed a writ application before this honorable court
That's right.
challenging that order.
So your point of territorial jurisdiction goes?
No, Your Lordship, territorial jurisdiction will not go.
You see section 21B.
Yes, 21B, but please just have a look to this judgment.
Yes.
Page number 16, paragraph number 19.
Yes.
While a High Court would normally not exercise its writ jurisdiction under Article 226, has your Lordship got that?
Yes.
Of the Constitution, if an effective and efficacious alternate remedy is available, the existence of an alternate remedy does not by itself bar the High Court from exercising its jurisdiction in certain contingencies. This principle has been crystallized by this court in such and such everything. A two-judge bench of this court, of which one of us has summarized the principles governing the exercise of writ jurisdiction by the High Court in the presence of an alternate remedy. This court has observed, this is important, Your Lordship, the principles of law which emerge are that the power under Article 226 of the Constitution to issue writs can be exercised not only for the enforcement of fundamental rights but for any other purpose as well. The High Court has the discretion not to entertain a writ petition. One of the restrictions placed on the power of the High Court is where an effective alternative remedy is available to the aggrieved person. This was the first point that he had taken, that as because there is a provision of appeal, that is why this writ application. Now, Your Lordship will please. Exceptions to the rule of alternate remedy arise where the writ petition has been filed for the enforcement of a fundamental right protected by Part 3 of the Constitution. B. There has been a violation of the principles of natural justice. C. The order or proceedings are wholly without jurisdiction. D. The virus of a legislation is challenged. An alternate remedy by itself does not divest the High Court of its powers under Article 226 of the Constitution in an appropriate case, though ordinarily a writ petition should not be entertained when an efficacious alternate remedy is provided by law. Now, Your Lordship, the point firstly that was raised by him, that there is an alternate remedy of appeal, that is why this should not be heard, that is categorically stated in this judgment of the Honorable Supreme Court. Thereafter, Your Lordship.
So you are coming under clause B and C both?
Yes, Your Lordship.
C, you see, therefore I was asking you about point number C.
The first, Your Lordship, there has been a violation of the principle.
Let us take it for.
Yes.
Let's take it that there has been violation.
Yes, Your
I'm
Lordship.
just you see, if there are multiple grounds to challenge an order, I'm seeking your specific response to ground number C. We will see natural justice also. What do you have to say to this?
Wholly without jurisdiction.
How is it wholly without jurisdiction?
Without jurisdiction, now please come to the order. Under challenge. Please come to the order.
No cause of action has arisen.
No cause of action has arisen, and they have already accepted the amount at Bangalore.
That acceptance has got no legal value. That issue has been decided by Supreme Court.
For the cause of action.
Have they stated that they will not make any claim? You see, what is happening is that in case of accident, etc., the employer are providing some assistance for the purposes of treatment, etc., merely because any payment has been made. That does not deprive them of their right to claim as per the workmen's compensation, employees' compensation.
So your Lordship may only take the first part without affording any opportunity?
Yes, natural justice, of course, will see that. So far as natural justice is concerned, let us see, the point of natural justice cannot be considered without the records. That will be required.
Yes, sir.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that although in the writ petition, the petitioner has raised the ground of violation of principles of natural justice, as well as the point that the entire proceeding is wholly without jurisdiction inasmuch as no cause of action has arisen before this court. The learned counsel has additionally submitted that the payment was made to the claimants when the accident had taken place at Bangalore, and therefore there was no surviving grievance against surviving grievance so far as the payment is concerned. During the course of arguments, the learned counsel for the respondent insurance company has referred to the provisions of section 21 within bracket B of Employees Compensation Act 1923 and has submitted that under the provisions of the same act, the case for claiming compensation can be filed in case of death of the employee by the dependent claiming compensation where they ordinarily reside. He submits that the applicants were the permanent resident of the district of Bokaro within the state of Jharkhand, and the case was filed in the district of Bokaro. At this, the learned counsel he has also relied upon the judgment passed by the Honorable Supreme Court in the case of Morgina Begum versus Managing Director, Hanuman Plantation Limited, reported in. This is Supreme Court judgment?
Yes, ma'am.
Citation SCC का बताइए कौन सा है इसमें?
Yes, ma'am.
Reported in
2007-11 SSC 616.
2007
11 SSC 616.
11 SCC
616.
617.
Madam,
At
I
this-
submit two judgments. One is related. You.
At this, the learned counsel for the petitioner has submitted that even if the jurisdictional point does not survive, but the fact remains that the impugned order has been passed in gross violation of principles of natural justice, and the petitioner has taken a specific plea that the notice was never served upon the petitioner.
At paragraph number 18
At paragraph number 18
of the writ application.
of the writ application. ये ऑर्डर कहाँ से पास हुआ है?
Bokaro.
In order to consider the aforesaid aspect of the matter, let the records of the case being EC case number 1 of 2020, decided on 25th day of January 2023, be called for from the Court of Learned Presiding Officer, Labour Court, Bokaro. आने दीजिए रिकॉर्ड करिए. देखिए नेचुरल जस्टिस का वायलेशन है.
My lord, I, as an insurance company, has no liability in this case. I am only assisting the court. Even the labor.
Which judgments are you citing?
Yes, two judgments. One is the limitation of High Court in the reappreciation of evidence without
That's
framing
वो तो हम
substantial
लोग
question
करने
of
नहीं
law.
वाले हैं. आगे.
And the second is the my lord's judgment that is related with the natural justice.
Natural justice can still be seen. We'll see that. It is made clear that the only point which survives from consideration is as to whether the petitioner was served with the notice by the learned court. That's it. Let this order be communicated through fax. Post this case on (27th November) in the supplementary process. The records of the case be accompanied with a report from the concerned court with regard to mode and manner of dispatch of service and the service report which might have been issued, which was issued by the learned. That report should also come.
Yes, sir.
From the daily list, item 1, sir, second appeal 416 of 2016.
Please, you first.
Milords, this second appeal is filed.
इसका रिकॉर्ड आया है.
Against the judgment of reversal, Milords. Milords, plaintiff filed title suit, Milords, and claimed half share of the schedule of properties mentioned in the plaint, Milords, solely on the ground that the half land of the property mentioned in schedule of land has been gifted, orally gifted, by the defendant number 1, father. Now he is deceased, his son is defendant number 1.
Just
Defendant
a
number 1
moment.
is
Defendant
father.
number 1 at that point of time was alive.
Yes, alive. He died during the pendency of
Oral
second
gift by
Milords.
defendant number 1.
Milords.
Defendant number 1 was contesting.
Yes, yes. Defendant number 1 died during the pendency of second appeal.
That's right. Okay.
Milords, Milords said the suit was admitted, Milords, by your lordships, by order dated 16th of August 2019, Milords.
No, you forget about it. We are finally hearing it. 1 घंटा बहुत है ना.
हाँ सर, हो जाएगा.
अब शुरू किया है तो अब खत्म करके.
Milords,
आज नहीं खत्म होगा तो कल कंटिन्यू करके खत्म.
हो जाएगा.
बताइए.
Milords, I pray that I have filed written argument on 11th of.
Written argument बात है.
अच्छा ठीक.
पहले आप उनको फाउंडेशनल फैक्ट बताइए, इश्यूज बताइए, फाइंडिंग बताइए.
Milords, I have already submitted before your lordship that.
भूल गए हैं हम पुराना. याद नहीं है. आप फिर से बहुत दिन हो गया ना.
That suit is claimed on the basis of the oral Hiba, which the plaintiff claimed that his father gave him oral Hiba, Milords, half of his land that is mentioned in the schedule of the plaint, Milords. Schedule of plaint covers schedule A, B, C, D, E. A, B, D, E are agricultural land, and schedule C is the ghar badi, Milords.
A, B, D, E are
agricultural
agriculture.
land, and C is the ghar badi, Milords. And on that basis, Milords, he has also produced PW's, Milords 6, and plaintiff is the PW 6, Milords. Milords, defendant appeared, filed WS, and claimed that he never gifted, orally gifted, any of his land to the plaintiff, Milords, and if he would have done so, means gifted the land, he must have executed a deed, Milords, and get it registered, Milords. And this father's other, defendant number 1, other claim is that why he will gift half of his land to only one of his son. He has one more son and 4 daughters. Therefore, the plaintiff has filed the present suit on wrong assumptions, concocted the facts, Milords, and filed this case, suit. Milords. Therefore, Milords, the issues were framed. There are altogether 7 issues, Milords. First issue is the suit maintainable? Second issue is, has the plaintiff valid cause of action?
Let us see the issues.
Milords, appellate court का judge, trial court का judge.
Trial court का judge.
Milords.
Page number बताइए.
At page 36, running page 36.
Yes.
Is the suit maintainable as framed? Has the plaintiff valid cause of action for the suit? Third, is the suit barred by staple, waivers and acquiescence? Fourth, had the defendant orally gifted his half land out of the lands mentioned in the schedules of the plaintiff to the plaintiffs? And fifth, had the plaintiff accepted the gift?
So bone of contention is only 4 and 5?
Yes, asal. Main issues यही है उसका.
यही है.
And
4 and 5 का क्या finding है?
ये paragraph 23. Paragraph 23 at page.
4 and 5 is at interval page 6.
At running page also 47, 23. Finding. Here it goes.
Yes.
Considering the entire evidence, documentary as well as oral, adduced on behalf of both the parties, and on after discussion made above, and also in the light of principles laid down by the Honorable Supreme Court and Honorable High Courts in different cases, I find and hold that plaintiff has failed to provide the fact of Hiba made by the defendant in favor of the plaintiff for any portion of the suit land. Therefore, both these issues are decided against the plaintiff and in favor of the defendant, and dismiss the suit.
There was sole defendant, only one defendant?
Only one defendant. No defendant. Milords.
That's
sorry, Milords. One more question. Sorry.
Only one defendant.
ने वो इंटरवीन किया. हाँ, सूट में सूट.
So,
they
father and son, they were at loggerheads.
Yes.
Then what happened in the appellate court?
बता रहा हूँ. Here, in the meantime, must submit one thing. Birthright do not give any right on the properties of the father. Say in Muslims, so far as the Muslim. Therefore, the partition suit.
No property devolves through birth.
Yes, due to birthright. So partition suit, अजीब सा बात लगता है. टाइटल सूट करते हैं. No, Milords.
No birthright on property.
Milords. No, Milords. The plaintiff filed title appeal, Milords. In title appeal, the judgment set aside, Milords.
Let us see the order by which it was
Yes,
set aside.
para
And let us see the discussion of the trial court judgment by the appellate
तो
court.
para 22 में आएगा. Trial court discussion, yes, Milords.
Trial court का discussion हुआ
Para
और
10
judgment
para
हुआ.
10 पढ़ देते हैं.
Para number 5 is the issue.
Para number 5 में issues. Yes.
Issues फिर से
Yes.
introduce किए हैं.
हाँ, वो वही 4 और 5 को मेन किए हैं. तो इसका जो डिस्कशंस है वो तो एविडेंस, ये तो विटनेसेस है. उसके बाद असल इनका है पारा 10 में होना चाहिए. पारा 11.
So these were the point of determination.
पारा 9, पारा 10 Milords.
Yes.
इंटरनल पेज जो है जजमेंट का वो 19. in the result, may I read?
Page number, sorry,
Internal page 19 also, इसमें
19. ठीक है?
In the result, question posed above at the beginning of the finding is answered in negative, while the learned court below was within its right in noting in the testimony of BW6 regarding making of Hiba and its acceptance and the respondent putting him in possession. It is revealed beyond its
It
jurisdiction.
travelled beyond.
Milords, travel beyond its jurisdiction in construing his further statement that since Hiba was not made after partition in mates and bonds, the same was his admission of lack of delivery of possession of half share of the property, or for that matter this witness himself failed to establish the ingredients of the Hiba. I find no merit in the argument of the respondent number 1. Rest of the respondents have no claim in this appeal. It is held that the respondent orally gifted his land, his half land, out of the lands mentioned in the schedule of the plaint to the appellant number 1, and appellant number 1 accepted the gift. In the result, the finding of the learned court below at para 8 नहीं होगा, ये 23 होगा. At para 8 of its judgment, while issues number 4 and 5 are hereby set aside, and both the issues number 4 and issues number 5 are answered in affirmative and in favor of the appellant's number.
ये पैरा 10 समझ में नहीं आया. ये पार्टीशन बाय मीट्स एंड बॉन्ड्स का क्या बात?
मैंने उनको जा करके
अच्छा, डिमार्केशन.
बात कर
डिमार्केशन.
ये बाउंड्री को स्पेसिफाई कर
असर्टेन
करके जी हाँ, वो सब कुछ नहीं किया गया. जब किया ही नहीं गया है तो फिर लल्लन ट्रायल कोर्ट का कहना है कि हाउ इट इज गिफ्ट में पोसेशन जो है, डिलीवरी ऑफ पोसेशन इज वन ऑफ द एसेंशियल इंग्रेडिएंट्स ऑफ द गिफ्ट.
तो अपीलेट कोर्ट क्या बोलते हैं?
अपीलेट करता नहीं, ये सब किया गया है.
ये सब किया गया है.
और
डिमार्केशन.
पोसेशन दिया गया, पोसेशन दिया गया. वो फिर पीछे
And
जो
what all are the acts of possession, giving and taking of possession, has been discussed by the learned appellate court.
वो ये उसके पहले वाला पैराग्राफ पे होगा, पैराग्राफ 9.
Constructive possession. ईवा में constructive possession भी होता है.
ये पैराग्राफ
Mutation
का
हो गया
कहना
था?
है
Mutation हो गया था?
नहीं, कुछ नहीं होती, कुछ नहीं, कुछ नहीं.
पानी के लिए देंगे.
ये पैरा 9 कहा जाए तो एक बार पढ़ देते हैं.
आप तो plaintiff है ना?
हम डिफेंडेंट.
हाँ, आप defendant है. Sorry.
हम फादर हैं.
हाँ, father. हाँ, ठीक है. So you want to say that nothing has happened, but in spite of that, the appellate court has decreed.
Me
the
lost. And set aside the judgment of the learned trial. In that connection, my lords, my specific case जो है वो learned appellate court ने भी decide किया है para 4.2. उसको देख लिया जाए, बहुत ज़रूरी है, very essential. 4.2 internal page 5.
बताइए.
Internal page 5, paragraph 4.2. For the respondent number 1, it is argued that in Mohammedan law, the provision of oral Hiba is made, but the transfer of property act provides that Hiba must be for a specific portion of land. But in this case, while in para 14 of the plan, the appellant has pleaded that half land was given, but it is not pleaded as to where the same was given or which specific portion of land was given, and under the circumstances, the pleading of oral Hiba has no truth. It is argued that the defendant of the suit examined himself as DW5 and denied the entire allegation it is argued that none of the, ये defendant 2 होगा हुजूर, ये mistake है, ये जो defendant number है वो 2 है, ये 5 यहाँ आ गया है. Entire allegation, it is argued that none of the witnesses of the oral Hiba are either aware of the suit land or the lands which were given allegedly in Hiba and could not identify the same by their khata number or plot number, etc. Impeaching even the plaintiff appellant's testimony, PW6 ये है plaintiff. It is argued that even in his examination in chief, he has failed to specify where the lands were given, and he is even unaware of the total lands of the respondent or oral or total agriculture produce or income of the annual rents paid. It is also argued that the appellant is further unaware of as to when the lands were partitioned by the respondent and his uncle, or as to where person got which portion of the land or the lands subject matter of partition were demarcated, or all of them indeed came in possession. Accordingly, it is argued that he is also unable to tell the boundaries of the suit land or on which date to which date he worked as Munshi in Odisha, and that in para 52 has admitted that Hiba was not made for any specific land and cannot tell as to for how much properties the Hiba was made. It is argued that the appellant has further admitted that he is now not cultivating the lands. It is argued that there is no documentary evidence of Hiba. It is argued that there has not been delivery of possession. It is argued that delivery of possession is one of the ingredients of Hiba, otherwise there is no Hiba. Now, the very important portion, my lords, reinforcing his case, the respondent number 1 adverted to the defendant's respondent number 1 evidence to cite that ये DW2 है हुजूर defendant number 1 जो है, has in para 4 deposed that he has not made any oral Hiba, and in the case he ever did so, he would have got a deed executed and registered. This is very important, my lords. अगर मैंने किया होता तो मैं deed बनाता और मैं registration कर देता. For the purpose, and that in para 5 further deposed that he is in possession in the entire lands and doing cultivation and feeding his family, and is also paying the annual rent, and the appellant on the contrary has failed to elicit anything relevant in the cross examination. So this defendant filed WS.
See, anybody once, so you are harping so much on this that he would have registered the deed. So anybody after doing Hiba may come up with a plea that I would have registered the deed. This is post facto.
ये नहीं किए हैं हुजूर, वो वही कह रहे हैं कि अगर मैं करता, इसलिए कि मुस्लिम लॉ जो है ना हुजूर, मुस्लिम लॉ में जो पर्सनल लॉ हिबा का है उससे अलग है एग्रीकल्चर लैंड का रूलिंग. तो इसीलिए उसमें क्या है कि आपको रजिस्ट्रेशन करना ही पड़ेगा.
एग्रीकल्चर
यस, नहीं तो नहीं होगा. सो फॉर एज अ नॉन एग्रीकल्चर प्रॉपर्टी इज कंसर्न, देयर इज नो नीड टू हमारी ओरल गिफ्ट उसमें अलाउड है, पेपर की भी जरूरत नहीं है, रजिस्ट्रेशन की भी जरूरत नहीं. सो नाउ आई एम कमिंग ऑन द,
कहाँ से बोल रहे हैं?
हाँ, नाउ आई एम कमिंग ऑन द
कहाँ से बोल
पॉइंट
रहे
ऑफ
हैं
लॉ.
कि
यस
नहीं,
यस.
see, when you are talking about agricultural and non-agricultural land, first you have to show from the records
Yes.
that this was agricultural and this was non-agricultural.
ये तो
Is there any finding or there is no dispute on that?
नहीं, डिस्प्यूट क्या है तो प्लेंट ही में है.
अच्छा.
शेड्यूल 1 to E आपको हुजूर को बता दिए, 1 to E, उसमें C जो है वो केवल घर बाड़ी है, बाकी सब तो एग्रीकल्चर लैंड. और ये disputed नहीं है. This question is not disputed. अब now the question जो है, law जो है, कि whether oral hiba can be done so far as the agricultural land is concerned. Therefore, this other
So far as Schedule C is concerned, you are not
नहीं वो भी घर बाड़ी है हुजूर.
घर बाड़ी है तो उसका तो हो ही सकता है.
हाँ उसका हो सकता है, ठीक है कर दिया, ठीक है, लेकिन उसमें उनको एक शेयर मिला है बस, उसके लिए कोई बात नहीं. अब उसमें ही ये होता है मूसा, एक कंसेप्ट मूसा का भी है कि अगर कोई चीज़ पार्टीशन नहीं हो सकती है तो उसका आप पार्टीशन कैसे कीजिए. खैर ये तो छोटा इशू, असल इशू है एग्रीकल्चर एंड नॉन एग्रीकल्चर एंड ओरल हिब्बा अलाउड और नॉट.
हम लोगों ने यहाँ इश्यूज क्या बनाया है?
किसने?
यहाँ पे हम लोगों ने इश्यूज
हाँ, वही हम
उसी अब इस बैकग्राउंड के साथ बस उतना ही इशू को सुनेंगे ना जो हम लोग बनाए हैं, उसके बियॉन्ड नहीं सुनेंगे.
ये 16/8/2019 का ऑर्डर देखा जाए. 16/8/2019. Counsel for the appellant submits the impugned appellant judgment is a judgment of reversal and submits that this second appeal is fit to be admitted on the very first substantial question of law as framed by the appellants. Admit, no notice need to be issued as the respondent has already appeared. Para 4. This court finds that this appeal is fit to be heard on following substantial question of law. Whether Mohammedan can transfer his occupancy holding by an oral gift, Hiba, and whether the learned court below has failed to properly consider this aspect of it. I'm not, no.
What is referable to occupancy holding is agricultural land.
Occupancy holding means, my lords, if a rayat is in possession over agricultural land for the 12 years, he is occupancy. तो ये तो ancestral है. And now I will put before your lordship the books, reference and the case documents. तो प्लीडिंग है मेरी कि अगर मैं करता तो रिस्ट्रिक्शन भी करता.
ये जो क्वेश्चन ऑफ लॉ फ्रेम हुआ है, आफ्टर हियरिंग व्हाटएवर यू आर आर्ग्यूइंग, इट नीड्स टू बी मॉडिफाइड, क्योंकि ये क्वेश्चन ऑफ लॉ बहुत क्लियर नहीं है. अगर क्वेश्चन ऑफ लॉ क्लियर नहीं होगा तो उस पर फाइंडिंग कैसे क्लियर? अभी जो आप बहस किए उसमें आप उसको रिफ्रेम करिए सब्जेक्ट टू व्हाट अदर हैज टू से. फर्स्ट यू आर सेइंग एग्रीकल्चरल लैंड, देन यू आर गिविंग अप शेड्यूल सी. If you say so, this could be an alternative. And whether the Hiba was actually proved or not, because there is an order of reversal. So this is something we need to consider. We can't ignore it in a case of an order of reversal. Whether the finding of the learned appellate court that that Hiba was not, that whether the ingredients for constituting Hiba was duly satisfied.
Here the question of law is that Hiba is not allowed, oral Hiba, so far as the agricultural land is concerned.
Was it a point which the parties contested before the was it a case of the defendant number 1 in his written statement that because of agricultural land this Hiba cannot have, this Hiba has no value?
This is not pinpointed, but I will place before your lordship para 4 and 5 of the WS.
Because there is no such issue framed by the appellate court or
वही तो मैं कह रहा हूँ हुजूर के कोर्ट बिलो ने भी एग्रीकल्चर लैंड को लेकर के हिबा का इशू नहीं बनाया है और अपीलेट कोर्ट, बट देयर इज प्लीडिंग इन WS एंड इन डिपोजिशन ऑफ evidence. And plaint itself which discloses that the 4 schedules land, one A, B, D, E are agricultural land and only C is Dharma. So, or this defendant has mentioned it in his WS as also in evidence.
Para number?
There is. ये तो ये बता WS WS para 5
Para 5 only?
of Tiwari. Para 5 of depositions.
Of deposition? Written statement बताइए.
Written statement है, वो भी है इसमें वो भी है WS का नहीं, WS का para 5 है, सॉरी.
हाँ. पढ़िए.
Yes. Para 5 Millards, page 2 है that the entire facts stated in the plaint are manufactured para 5. There is no doubt. And the plaintiff intends to harass the old father of the brother. Accordingly, instituted the present suit only with an intention to harass them. Accordingly, the plaintiff cannot put a single sheet of paper to show that really he has got any interest with the suit land, as the entire land shown in the schedule are the ancestral land of the defendant, and there is no document of transfer of any piece of land. Accordingly, the suit is not maintainable, as in the lifetime of the father, the son is not entitled to get share in property. There is no document of transfer of any piece. Yes, please. So, कोई ट्रांसफर का डॉक्यूमेंट नहीं है और
ये तो बात नहीं है ना, बात हम लोग दूसरे पॉइंट पर. अभी आप चाहते हैं कि सेकेंड अपील में ये डिसाइड हो that there cannot be any transfer of agricultural land. So have you taken such plea in the written statement that this is that irrespective of whether the Hiba and the proceeding of Hiba, whatever the process was completed or incomplete, the property could not have been transferred because it is an agricultural. Have you taken such a plea?
ये WS में ये नहीं है.
तो फिर आप ही बताइए, अगर आपने
पेपर नहीं,
ये ट्रांसफर का पेपर नहीं है, वो तो whether the Hiba is valid or not. अगर Hiba वैलिड है कि इनवैलिड है, अगर ये पॉइंट होगा तो आपका सारा ही शेड्यूल प्रॉपर्टी है, ठीक है, राइट. But when you want to carve out a separate issue whether this property could have been transferred being an agricultural land through Hiba, it is a distinct issue altogether. It's a distinct point.
But in the WSV laws, it is stated that there is no paper showing transfer.
That's right. That is a separate thing. There is no paper showing transfer. So that is not sufficient.
और इसको सुन लिया जाए. और
was it a case? Okay. Now in WS you do not have. Was that a case of the plaintiff that this 3 property are agricultural land and this is a घरबाड़ी? ऐसा करके कुछ केस था इनका?
उनका शेड्यूल ही नहीं तो हुजूर.
ऐसे शेड्यूल देखे नहीं समझ में आता.
शेड्यूल 1 से E तक है उनका प्लेंट में, तो प्लेंट नहीं E का ऊपर बोला. पेज 9 शेड्यूल जो स्टार्ट हो रहा है पेज 8 से हो रहा है, A B C D करके. ये तो प्रेयर हो गया, सॉरी लीव्स हो गया. ये शेड्यूल ए पेज 9 से स्टार्ट होगा. खाता नंबर, प्लॉट नंबर और लास्ट पोर्शन में है नोट इस इतना पार्टीशन ऑफ लैंड एट विलेज पोलपोपुर PS डाल्टनगंज इन डिस्ट्रिक्ट रांची. खाता नंबर ये है, प्लॉट नंबर ये है, एरिया ये. इसमें जो T3 है, T2 है, इसका मतलब टाण माने वो एग्रीकल्चर है. T2, T3, T3, T2 इस तरह से लिखा हुआ है। ये शेड्यूल ए हुआ। उसी तरह से शेड्यूल बी देखा जाए, इसमें है D3 मैंने धान का 3 और D3, ये भी एग्रीकल्चर लैंड है। शेड्यूल सी देखा जाए, पर्टिकुलर्स ऑफ लैंड, कहा था इतना इतना इतना, ये घर बारी लिखा हुआ है। शेड्यूल डी देखा जाए, जिसमें भी T2 टार 2, उसके बाद ई देखा जाए D3 एंड धान 3 धान 3। सो इट इज इन द प्लेंट इटसेल्फ बिलोंग्स। और फिर वो जब उड़ीसा गए थे तो उनकी प्लीडिंग है कि आई हैव गिवन द लैंड टू माय फादर।
देखिए ऐसा है कि सेकेंड अपील में हम लोग इस तरह से हर इशू को नहीं खोल सकते। आपने जो इसमें इशू बनाया है उतना तक कंफाइन करिए, उसको बियॉन्ड क्यों जा सकते। योर इशू इज वेदर मोहम्मदन कैन ट्रांसफर हिज ऑक्यूपेंसी होल्डिंग बाय एन ओरल गिफ्ट हिबा। इसमें तो कोई डाउट ही नहीं है कि मोहम्मदन कैन ट्रांसफर हिज होल्डिंग बाय हिबा।
एग्रीकल्चर लैंड,
एग्रीकल्चरल लैंड बोल के तो इसमें इशू नहीं बना है ना,
वो ऑक्यूपेंसी
ऑक्यूपेंसी
यस 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 इशू हो गया।
And
इसका हम लॉ में दिखा देते हैं।
occupancy holding should be taken as equal to agricultural
Yes,
land.
my lords.
हमको नहीं पता है।
Sorry. और इसमें पर्सनल शरीयत एक्ट जो है लागू हुआ है कि what portions of Muslim law will be applicable in India, वो उसका पर्सनल लॉ 1937 है, उसको हम इसको रखो। ये इसका प्रतिवादी का एक जो है वो डिपोजिशंस, वो भी थोड़ा सा हम पढ़ना है। डिपोजिशंस DW2।
ठीक है, एक ऐसा इशू हम लोग यहाँ पे फ्रेम कर लिए हैं जो एक्चुअल में मतलब कहीं पे फ्रेम नहीं हुआ।
ये इशू कहीं फ्रेम नहीं हुआ। बेसिकली सूट में इस इशू को फ्रेम होना चाहिए। Although there is in WS and evidence of defendant that there is no cheat of paper, if I would have given, I must have get it document and registered, ये सब कहीं नहीं, ये सब है, लेकिन इशू नहीं थे। ओरल गिफ्ट जो मुस्लिम ओरल गिफ्ट है, उसके कॉन्फिडेंस, उसके रिक्वायरमेंट्स को लेकर के ट्रायल कोर्ट हैज रिजेक्टेड।
क्या हम लोग इसको देखिए, क्योंकि हिबा का जो अगर मान लीजिए हिबा itself was not proved, then it covers everything, A to E, schedule A to E, right? There is an order of reversal on the point of hiba. तो हम लोग at best हम लोग यही कर सकते हैं ना कि whether hiba was proved or not proved, that can be considered.
But there is no concept of oral hiba in Muslim law. The thing is that law is but law.
No concept of oral hiba in connection with agricultural land.
Yes, yeah.
You see, ये जो आप carve out कर रहे हैं ना, प्रॉब्लम इसमें ये है कि इस तरह के इशू वी हैव नॉट जॉइंट इशू ऑन दैट। भाई these are the issues which were required to be specifically framed. ये कोई ऐसे हवा में थोड़े इशू बन सकता है।
नहीं, हवा में कैसे हो सकता है? क्योंकि सब्सटेंशियल पोर्शन ऑफ लॉ पर ही सेकंड अपील।
भाई आपने अपना ट्रायल किया, ठीक है, ट्रायल में इश्यूज सुन के ही डिसाइड होता है, उसमें आपने ऐसा कोई इशू नहीं बनाया,
इशू नहीं।
उसके बाद अपील किया, ठीक है, अपील में भी इस तरह का कुछ भी नहीं हुआ। अब यहाँ पे आउट ऑफ द ब्लू इस तरह का इश्यूज हम
आई एम नॉट प्लेंटिफ नॉट्स, आई एम डिफेंडेंट।
भाई जब इशू फ्रेम होता है तो प्लेंटिफ डिफेंडेंट दोनों को सुन के फ्रेम होता है ना,
दोनों को सुन के होता है।
तो देखिए ये एक सेकंड, you see, we are just talking in your interest and both of the parties' interest. At best, the issue could be, we can also reframe the issue. ऐसा कोई legal bar नहीं है in the second appellate jurisdiction. At best, the issue would be whether the hiba was duly proved. At best, because there is an order of reversal. we may need to consider the evidences.
तो यहाँ in this case
अब आप पूरा उस इश्यू से हटकर आप बोलते हैं कि हिबा हुआ नहीं हुआ इसका कोई मतलब नहीं है क्योंकि एग्रीकल्चरल लैंड में हिबा हो नहीं सकता, यही आपका कहना है?
ये हिबा ओरल नहीं हो सकता, ओरल नहीं हो सकता।
हिबा भी दो तरह का होता है, रिटन एंड ओरल।
यस मिनट्स, यस मिनट्स,
ओरल हिबा नहीं हो सकता।
नहीं हो सकता।
ये आप कहाँ से बोल रहे हैं?
अब केस लॉ
नहीं, लेकिन ये थोड़ा सा ना ये इशू
और सुन लिया जाए हमको, फिर योर लॉर्डशिप विल बी प्लीज्ड टू पास दिस क्वेश्चन ऑफ ये क्वेश्चन।
आप इसको नहीं, आप इसको क्वेश्चन ऑफ लॉ को रिफ्रेम करें।
तो इसको एक बार मेरा वो आर्गुमेंट और सुन ले, उसके बाद उसको
What do you say on the framing of this question of law?
But since this point which has been raised, that was already answered by a division bench of this honorable court as early as in the year 1963, that was in B.B. Manigan's case, where this issue whether occupancy holding can be transferred orally or not, that was said, decided in affirmative, yes, it can be done, even taking into consideration Shariat Act, it was said, and that decision we have here. So that is where I probably unnecessarily harping upon the issues which were never.
Which was already decided.
This has already been decided. So the
Mr.
question of law, substantial question law, is not to be framed on a question which has already been decided. That's one, Santosh Hazari's case. Then second point, which जो हुजूर का कहना है, that Hiba was properly proved or not proved, because this relates to a question of fact, unless it can be shown that the finding is perverse, the second appellate court will not interfere into the question of fact.
Yes. Therefore, in order to come to a conclusion whether the finding is perverse or not, that also has to be seen.
Automatically नहीं होगा ना, perverse के लिए pleading लाना होगा ना. Perversity comes, I mean it's not a case, since the perversity is a word which will require, because since अभी तो आज इनका occupancy holding पर का बात था, हमने उस पर डिसीजन दिखा दिया कि डिवीजन बेंच का डिसीजन है, पढ़ लिया जाए, कोई हड़बड़ी नहीं है हमको, लेकिन that question has already been negative. अब मैडम जो कह रही हैं, she is saying कि she is trying to, formulate the issues. Perversity के लिए हम लोग को पूरी फाइंडिंग्स को देखना पड़ेगा, और फाइंडिंग्स को बिना देखे हुए personally looking at one paragraph.
जब कोई कोर्ट ये बोलता है कि इसमें कोई परवर्सिटी नहीं है, तो वो देखते ही बोलता है ना, कि बिना देखे बोलता है।
नहीं, अभी हम लोगों ने जजमेंट का हाफ कहीं पर से दो चार आइसोलेटेड क्वेश्चंस देख लिया है, और अदरवाइज परवर्सिटी पर अगर आप बोलेंगी तो परवर्सिटी पर पूरा बहस कर सकते हैं, हमको कोई प्रॉब्लम नहीं है कि देयर इज नो परवर्सिटी इन द ऑर्डर, बिकॉज इट वाज, इनका कहना ये है, प्लीडिंग्स जो था इनका, कि अगर हमने दे भी दिया तो चूंकि वो उड़ीसा चला गया, ही लेफ्ट द प्रॉपर्टी टू द कस्टडी ऑफ हिज फादर. मुस्लिम लॉ में एक किताब है, ये डर उल मुख्तार, एक मिनट, अच्छा हाँ, डर उल मुख्तार जो है ये 1070 में लिखता है, नहीं ये किताब जो है ये इनका अथॉरिटी है, that has been followed in by the honorable supreme court.
ये किताब तो हमको मंगाना पड़ेगा ना,
हाँ, डर उल मुख्तार,
तो आप तो हमको दीजिएगा नहीं?
हाँ दे देंगे. एक मिनट हुजूर, इसमें लिखा क्या है, इंट्रोडक्शन, हम भी बहुत क्यूरियोसिटी से इसको पढ़ रहे थे. डर उल मुख्तार was written in the year 1070 Hijri by Sheikh Muhammad Alauddin, was Mufti at Damascus for a long time. The present volume is treated as an authority, translated by Justice M.B. Dayal. और इसमें अभी किताब में हम देख रहे थे, एक साइड जो है उर्दू है, एक साइड इंग्लिश है, उसमें हिबा का पूरा कॉन्सेप्ट्स दिया है, and that was followed by Justice S.V. Sinha in 2009 volume 6 decision, and that was also followed in Hafiza BP, and I have got that
2009 वॉल्यूम 6 बताइए तो कौन-कौन से साइटेशन?
एक मिनट हुजूर, जरा सा एक लाइन से शुरू कर रहे हैं. इसका पहले जो कंसेप्ट ऑफ हिबा है, वो ओरल वाला जो है उसको जरा सा देख लेते हैं. एक मिनट, हम लोग एक डिसीजन को जो बीबी करी क्या है, इसमें यही इशू था, ये डोरंडा म्युनिसिपैलिटी का था, पहला पेज में ही दिखा हुआ है, डोरंडा का ही था, एग्रीकल्चर लैंड भी पढ़ते हैं। The appeal of the defendant arises out of the suit for partition, which was decreed by subordinate judge. The suit property consists of the some houses, equated Doranda notified committee, and some agricultural plots belonging exclusively to Muhammad such and such and such and such. The point which was taken by the council in para 7, that in respect of non-agricultural land, Muslim law is not applicable. Then it was answered in para 11.
Muslim law not applicable, yes.
ये argument था brother, थोड़ा सा।
अच्छा सॉरी, असल में हम पढ़े नहीं है।
पढ़े नहीं है तो पढ़ लीजिए ना, फिर काहे के लिए
पढ़ लीजिए भाई,
पढ़ लीजिए, हम लीजिए आपको
नहीं आप
उसमें ये पॉइंट लिया गया, शरीयत एक्ट का पॉइंट लिया गया। तो बंगाल आगरा असम सिविल कोड्स एक्ट का सेक्शन 37 वाज टेकन इनटू कंसीडरेशन, दैट अगर आएंगे हुजूर उसमें स्पेसिफिक पैराग्राफ है जो देयर वर 2 पॉइंट्स फॉर कंसीडरेशन, एंड बंगाल आगरा असम एक्ट में कहता है 2 थिंग्स, द लॉज इन रिलेशन टू मुस्लिम्स, इसमें है इंटरनल थर्ड पेज पर जाएंगे हुजूर, नीचे मिलेगा एक्सप्रेशन रूल ऑफ मोहम्मदन लॉ, थर्ड पेज जो जजमेंट का है, पैरा 10। द एक्सप्रेशन, पहला 2 पैराग्राफ को छोड़ करके सेक्शन 129 पे जो है सही है। The expression rule of Mohammedan law covers all such rules which are enforceable by the civil court at the relevant enactment under section 37 of Bengal Agra Civil Codes Act. The clause 1 reads, where in a suit or other proceedings it is necessary for a civil court to decide the question regarding succession, inheritance, marriage, caste, or religious usage or the institution of Mohammedan law. In cases the parties are Mohammedan, the Hindu law, in case where the parties are Hindus, such and such shall be. And the second clause says that in cases not provided by subsection 1 or any other law for the time being, the court shall act in accordance with justice, equity and good conscience. Then the court answers this. यहाँ आ जाएगा 4th पेज में, पैरा 12 के जस्ट पैरा 12 के जस्ट 3-4 lines ऊपर में, as the central legislature has no power in 1937 to make the law in respect of agricultural land, why the reasons were there in the Shariat Act. The Act applies to non-agricultural property only, but the Act supports the view for the custom and usage to the contrary. The rule of Mohammedan law applied to gifts even prior to enactment of this Act. The correct position therefore is that the Shariat Act and the Mohammedan law of gift applies to non-agricultural property on account of section 2 of this Act and to agricultural property on the ground of justice, equity and good conscience. Hence the contention of Mr. Lal Narayan Sinha fails. And lastly, the conclusion, it must be held that the oral gift made by such and such in favor of his wife Bibi Banire is...
So under a limited circumstances, it can be said that oral gift
is not prohibited. Oral gift in relation to agriculture. और यहाँ जो शरीयत एक्ट है वो भी हम लाए, शरीयत एक्ट का सेक्शन 3 देखा जाए, सेक्शन 2 ब्रदर बोल रहे हैं, सेक्शन 3 देखिए है यहाँ पर क्या?
आज जो है ना,
एक सेकंड, खाली एक ही सेकंड टाइम लगेगा, इनका शरीयत एक्ट लगेगा कि नहीं लगेगा वो भी जरा क्लियर हो जाए।
सेक्शन 2 भी पढ़ लिया जाए।
अब पहले 3 तो मत जो है तो हम पढ़ ही दिए हैं ब्रदर, 3 को पढ़ लें, थोड़ा सा ज्ञान लें ना, हमको सीखने की इच्छा है। अरे आपका मुस्लिम लॉ मिला है,
ऐसा कोई लॉ नहीं है कि मुस्लिम लोग ज्यादा मुस्लिम लॉ जानते हैं।
Yes, my lords, yes, that is.
There is no such law.
Mullah itself was not a Muslim, my lords.
I don't know.
Yes.
ऐसा presumption हम बिल्कुल नहीं रखेंगे.
ये दिनशाह फरूद्दीन मुल्ला, ये तो मेरे पास ये फोटो भी है इनकी.
हाँ,
ये was मुस्लिम
ना नहीं भाई.
ना उसके पास था. अच्छा खैर, anyway section
इन्होंने हिंदी लॉ भी लिखा है. बहुत
एक section 3 power to make declaration. मिला है. Any person who satisfies the prescribed authority that he is a Muslim.
Section 3.
Section
The
3.
rule of Mohammedan law that have been expressly directed to be applied to Mohammedans. Introduction of Mohammedan law into India.
शरीयत है.
भाई इस जरा आप ही निकाल के दीजिए कहाँ है.
अपेंडिक्स में
दिखाइए.
Right.
उसी किताब से निकाल के दीजिए, वो मेरी किताब वापस आई.
एकदम दे रहे हैं.
अपेंडिक्स 9 देखा.
दे रहे हैं. तो कहाँ है?
हमको ऐसा लगता है कि इसमें तो हम लोग सुनेंगे ही, है ना, लेकिन ये पॉइंट ऑफ लॉ इसमें है.
तो सेक्शन 3 जरा सा देख लीजिए, आप तो किताब में जरा देख लीजिए, हम इधर आपका भी निकालते हैं क्योंकि टाइम खत्म हो रहा है कोर्ट का.
हाँ.
वो चीज दिमाग में रहेगा तो अगले डेट पर कम से कम काम देगा.
कल
तो छुट्टी है.
ओ, कल तो छुट्टी है. ये सब चीजें कंटिन्यूटी में सुनने की चीजें हैं.
सेक्शन 3 जो है वो ये कहता है पावर टू मेक डिक्लेरेशन. बिला हो any person who satisfies the prescribed authority that he is a Muslim, that he is competent to contract within the meaning of such and such, that he is resident of such and such, may by declaration in the prescribed form filed before the prescribed authority declare that he desires to obtain the benefit of the provisions of this section. Then thereafter the provisions of section 2 shall apply, and thereafter the provisions of section 2 shall apply to the declarant and such and such. So, where is the case that I have made an affidavit before the prescribed authority that I shall be going by this? Then section 2 will apply. अब brother section 2 को apply करा दे, हमको कोई अर्जन नहीं. Section in case of application section 2, the writer is that section 2 will apply only when the person files an affidavit before the competent authority, prescribed authority, that he wants to take the benefit of the Sharia.
That is a condition precedent.
That is a condition. Thereafter. तो क्या किया जा सकता है? अब ब्रदर बोल रहे हैं तो
the entire case is also decided on the basis of the Sharia law. Where is the declaration of the plaintiff also?
ये ना कहाँ डिक्लेरेशन चाहिए भैया? आप कह रहे हैं कि हमको शरीयत लॉ से एग्रीकल्चरल लैंड पर नहीं लगेगा. उस पे ऑनरेबल पटना हाईकोर्ट ने कहा कि 1937 में जो यूनियन लिस्ट और स्टेट लिस्ट थी उसमें सेंट्रल गवर्नमेंट को ये पावर नहीं था कि वो एग्रीकल्चरल लैंड के बारे में लॉ बना सके. इसलिए वो शरीयत लॉ जो उस वक्त बना, एप्लीकेबिलिटी ऑफ शरीयत लॉ, 4 सेक्शन ही तो है ही है. उसमें कहा कि वो नॉन एग्रीकल्चर लैंड है, लेकिन वो जो बंगाल एग्री एसेंट सिविल कोड एक्ट का सेक्शन 37 का सब क्लॉज 2 को देख करके ऑनरेबल कोर्ट ने वेरियस डिसीजंस को टेकिंग इनटू कंसीडरेशन हैड कम टू अ कंक्लूजन दैट यस हिबा कैन बी मेड ऑफ एग्रीकल्चरल लैंड बिकॉज इट इज कवर्ड बाय इक्विटी गुड कॉन्शियंस. And that point was this oral hiba of Ranchi itself, the Donda Municipal Corporation and the agricultural lands were held to be valid in favor of them. And so far as the possession is concerned, in the 1922 का Privy Council का decision है, बड़ा interesting है. Husband ने wife को दे दिया हिबा. उसके बाद भाई जब तक जिंदा था तब तक उसी घर में रहा. तो यहाँ पोजीशन का पॉइंट उठा तो हुआ कि इसमें अल्टीमेटली प्रिवी काउंसिल ने आंसर किया कि भैया द पार्टीज आर रिलेटिव, देयर इज नो नेसेसिटी टू डिपार्ट विद द पोजीशन. तो इफ ही इज
इसमें हम इसमें एक एडिशनल पॉइंट ऑफ लॉ हम बनाना चाहते हैं
हम आपको इस पॉइंट पर असिस्ट कर देंगे, एडिशनल पॉइंट आप बनाना चाह रहे हैं इसलिए क्योंकि ये पॉइंट तो फेल है।
इसलिए नहीं, कोई मेरा केस थोड़ी है।
नहीं
We are looking at the facts of the case,
हाँ
and during the course of hearing, we find that there is an judgment of reversal by saying that the basic ingredients were
in
not
all cases of
satisfied.
judgment of reversal we will be framing an issue that it will be purpose. In all cases of reversal it will be purpose unless we come to the foundational fact. Where are the foundational
Then
facts?
you see, in order to frame an issue
Milords.
that there is a defect in the order of reversal, you have to satisfy this court that there is a perversity. Once you satisfy this court, there is a perversity. We will frame a specific issue on that. Prima facie, if you are able to satisfy this court that there is a perversity, then we will frame a specific issue on the point of reversal, and we'll decide that also. We are not saying that this issue will not be decided. We'll see what is to be done. We have to see whether there is proper pleading, proper.
एक गलती हो गई, आपके किताब में हम नहीं निकाल के दिए हैं, लगे निकाल दें।
ये आपकी किताब है क्या?
हाँ, ये
हाँ भाई, ये वापस करिए और हमको। इस केस में लगता है हमको पूरा मुस्लिम लॉ पढ़ना पड़ेगा। अच्छा है ना?
अच्छा।
नया चीज़ है मेरे लिए। हम आज तक कभी मुस्लिम लॉ में एक तो केस डिसाइड किए थे, वो सिंपल सा कुछ था, याद नहीं।
और भी बहुत सारे
देखिए, एक सेकेंड अपील का क्वेश्चन ऑफ लॉ पे रिसेंट जजमेंट है, इसको आप जरूर देख लीजिएगा। दिस इज इन चंद्रभान वाला जजमेंट देखिए आप लोग। दिस इज डिसाइडेड ऑन 22nd of September 2022. September 2022. Chandrabhan deceased through legal representatives versus Saraswati and others.
निकाल दिया मुझे इसमें 461।
ठीक है, thank you. This is SLP civil number 8736 of 2016.
हम देखे हैं,
जरूर देखे होंगे। देखिए, यहाँ पे एक प्रिंसिपल है, and inference of fact from the recital or contents of a document is a question of fact, but the legal effect of the term of that document is a question of law. Construction of a document involving the application of any principle of law is also a question of law. Therefore, when there is a misconstruction of document or wrong application of principles,
that was the earlier law in Hero Vinod case. This was that probably Hero Vinod case they have cited. In Hero Vinod case, as
a substantial question of law will also arise in a contrary situation where the legal position is clear either on account of express provision of law or binding precedents, but the court below has decided the matter either ignoring
misapplication of the law
or contrary to such legal principle.
Misapplication of law कहीं तो दिखा दें, तो हमको कोई problem नहीं। There is no misapplication of law, rather there is a direct application of the law, because in the terms of Supreme Court decision in Hafiza's case 2011, that was clearly about the oral Hiba, and that decision has been cited by the London Appellate Court in the Hafiza's case.
हमने जो साइड किया हुजूर, वो मुसलमान बीबी शरीफा।
शरीफन भी आपके अगेंस्ट में ही है, शरीफन भी आपके अगेंस्ट में मैं लाया।
फर्स्ट लाइन ही स्टार्ट होता है।
अरे ब्रदर, अभी अलाउ हुआ है।
हाँ भाई,
वो एग्रीकल्चर लैंड का था, हमारे पास है बीबी शरीफन, हम लाए हैं। आप ही के अगेंस्ट में है, अभी अलाउड हुआ है।
सर, आप थोड़ा सा हमको परवर्सिटी पर एड्रेस कर दीजिए, हम उस इशू को भी फ्रेम करना चाहते हैं।
इनका वाला डिसीजन जरूर रखिएगा, डिसीजन इनके अगेंस्ट में है। बीबी शरीफन लाए, आपको बीबी शरीफन
वो फाइल भी किए,
प्रभु आपके अगेंस्ट में है।
ठीक है,
अब आप लोग कब करिएगा ये बताइए। अब ये छुट्टी के बाद का कहानी मत सुनाइए। अब ये एक बार फाइल खुलने के बाद जो है ना, इतना पेशेंस नहीं होता है, इसको बंद करेंगे सुनने के बाद।
खत्म तो आज ही है, अगर इनका जो क्वेश्चन ऑफ लॉ बना
नहीं, सिर्फ इतना क्वेश्चन ऑफ लॉ नहीं है इसमें कुछ क्वेश्चन ऑफ लॉ और भी।
हाँ ठीक है, तो that has already been decided by a division bench.
नहीं, कुछ क्वेश्चन ऑफ लॉ और भी है which arises out of this. We will
that
see.
has not been framed.
And
the law in relation to that is that you cannot abruptly frame a substantial question of law unless.
No. Therefore, unless the parties argue on that, we can always reframe the question of law. There is no legal bar because during the course of hearing,
subsection 5 always gives a power.
Yes. Therefore, during the course of hearing, if something transpires, but he has to demonstrate that it is transpired. You have to show the perversity in the first appellate court judgment
If
to
it can be shown.
frame a substantial question of law on this question of fact also.
And what is perversity also, that is also important.
Perversity
because there are
is-
a number of decisions on that.
Perversity is
Simply an error of law, simply an error of fact is not a
Perversity is
perversity.
non-consideration of a material evidence on record or consideration of a fact which is not there on record.
Rather, the perversity wasn't part of the trial court because it said that though the witnesses have stated this, but since the possession aspect has not been proved, he has disproved the Hiba only on a point that the possession was not there. Nothing else. That he accepts that the oral witnesses have proved it. Witnesses who were present at the place, they have said that.
अच्छा बताइए आप लोग कब करेंगे
Defendant
बताइए
is not accepting.
बताइए कब करेंगे
हमको कोई problem
कब करेंगे बताइए
लेकिन ऐसा दिन रखा जाए हमको आज होल डे हम टाइड अप रहेंगे इस मैटर
नहीं,
सैटरडे
हम-
भी आए थे
हम ऐसा ही दिन अभी देखिए कोई सैटरडे खुला हुआ है किसी दिन अभी तक कोई सैटरडे खुला
हाँ
हुआ है
छुट्टी होती है
छुट्टी नहीं कोर्ट जिस दिन खुला हुआ हो उस दिन
सैटरडे हम रहता है खुला हो तो भी नहीं आते हैं हमको
आप तो इतने सीनियर हैं हम लोग तो हम लोग को
सुनने की बात नहीं है थक जाते हैं मोराबादी से गाड़ी ड्राइव करके यहाँ तक आने में हमको
ये
लंबी सी गाड़ी है बहुत
मिस
बड़ी।
इंटरप्रिटेशन का जो मामला मिस इंटरप्रिटेशन ऑफ मुस्लिम लॉ उसको हम जो सब्सटेंशियल लॉ है नंबर 4 उसमें हमने मेंशन किया है वेदर और नॉट जजमेंट एंड डिग्री ऑफ लर्नेड कोर्ट बिलो सफर्स फ्रॉम मिस इंटरप्रिटेशन ऑफ मोहम्मदन लॉ ऑफ हिबा पब्लिक गिफ्ट और प्रोसेस ऑफ लॉ एक भी फ्रेम किया है whether or not learned appellate court below met the
निकलते हैं
reasoning
हमको
of
गाड़ी
learned
ड्राइव
trial
करने में
court
दिक्कत हो
below.
जाएगी बहुत दूर जाना रहता है
ठीक है इसको रख दिया जाए उस दिन हम लोग इस पर डिस्कस करेंगे जो फर्दर क्वेश्चन है
आपको कुछ फर्दर क्वेश्चन ऑफ लॉ बनाना है तो बना के लेके आइएगा उनको सर्व करके और नहीं तो जो आपका क्वेश्चन ऑफ लॉ है उसी में डिसाइड कीजिए यू थिंक ओवर
परवर्सिटी पर
हाँ परवर्सिटी पे देख लीजिए अगर आपको लग रहा
मिसकंसेप्शन ऑफ मुस्लिम
है what the learned counsel appearing on behalf of the parties
और इसमें सिंपल सबमिशन और भी बहुत सारे एक्ट्स जो है उसमें भी साफ लिखा हुआ है कि दिस एग्रीकल्चर लैंड के लिए ऑर्डर रिबार नॉट सब हमला है
the core issue which has been argued, the point which has been argued by the learned counsel for the petitioner, by the appellant is that Hiba is not permissible. Hiba / oral gift is not permissible / in bracket is not permissible for agricultural land. As the court time is over, post this case for further hearing on. बता दीजिए मैं कौन सा दिन करिएगा
आफ्टर petition कर दिया
बस सेकेंड हाफ में इससे एक ही केस सुनेंगे उस दिन दूसरा केस
ठीक है सर ठीक है सर
ठीक है ये टाइड अप मैटर है इसको हम इतना दिन तक 2016 का सेकेंड अपील हम इतना टाइड अप नहीं रख सकते
13th of
December हम भी पढ़ेंगे ना थोड़ा
ठीक है
to be taken up at 2:15 as first case
बता देंगे
उनको बता देंगे ठीक है
और उस दिन एक बार मेरा डिटेल
13th नहीं rather 12th दिसंबर को रखते हैं 2:15 के लिए 12 तारीख और अगर मान लीजिए डिसकंटिन्यू अगर मान लीजिए कंक्लूड नहीं होता है तो 13 तारीख 12 13 12th of December 2024 at 2:15 if the matter is not concluded on the same day it will continue to be heard on 13th of December बच गया
एक कंटेम्प्ट था सीरियल 58
क्या हो गया
अपोजिट पार्टी यूनियन ऑफ इंडिया था तो ऑर्डर का कंप्लायंस नहीं हुआ
कौन है यूनियन ऑफ इंडिया की तरफ से देखिए 4:30 बज गया अभी किसी के
कंप्लायंस का
अरे नहीं आप क्यों इतना एजिटेटेड? हम आपको बिना खोजे कोई ऑर्डर नहीं करेंगे। 4:30 बजने के बाद हम उसी का ऑर्डर करेंगे जब दोनों पार्टी।
ऑर्डर 3 महीना में ही कंप्लायंस करना था और ये 8 महीना से ऊपर हो गया इसीलिए।
We have filed on CMP for extension of time when they were having, we have filed on CMP. So now we got the filing number also.
CMP आप अपना प्लेस करा देंगे। आप लोगों को क्या परेशानी है बताइए?
एक सप्ताह में ऑर्डर था फॉलो अप एक्शन टू पुट बैक इन सर्विस। 19 जून का ऑर्डर है, अभी तक कंप्लाइंट।
कितना बैच बच गया? कंटेंट कितना बच गया?
ज्यादा नहीं है, 10 को भी लगभग। ये तो मंडे के लिए भी
मंडे को 215 के लिए।
हाँ, मंडे
आप जो
को।
बोल रहे हैं कंटेंट जितना भी रिमेनिंग है मंडे को बट इट विल बी टेकन अप एट 4 o'clock।
यस,
उसके पहले नहीं होगा। 4 बजे के पहले इसको करना है और 4 बजे आए।
ठीक।
Earlier rejected मतलब juvenile bail matter मतलब it was mentioned and passed over मतलब subject to lordship
Mention and pass over. When
mentioned
was it mentioned?
मतलब it was mentioned white slip yes मतलब
But you
last
never appeared when the case was called out.
मतलब I was मतलब it was serial number 61 I was in under the impression that it will take by seriatim.
No, आप नोटिस नहीं पढ़ते हैं।
मतलब it's my
Now it has been adjourned. I can't do anything.
subject to convenience मतलब if Monday Tuesday any date मतलब
No, it can't be. You see, जब आपका next date होगा
as your lordship.